A. Carmen Erickson. Defendant and all counsel are present.
Thank you. Before we begin, I'm going to do even before housekeeping. This may be a point of personal privilege. I would like to take a picture with both teams before we get too withdrawal on what we're doing. Can we have the teams come up?
Okay, prosecution come up. Prosecution. Stand by. All the team members from prosecution. Coaches. Jury advisors.
Good morning, Your Honor. My name is William Miller, and along with my co-counsels, Sharon Duvall,
Good morning, Your Honor.
Elijah Wallach,
Good morning, Your Honor.
Good morning.
we will be representing the people in today's case.
Thank you. Please remain standing.
Would you like a copy of our roster?
Yes, I will. Please stand.
I approach.
And for the defense.
Good morning, Your Honor. On behalf of the defendant, A. Carmen Erickson, my name is Taylor Dickerson, and I'm joined by my co-counsels, Calder Weiss
Good morning, Your Honor.
and Alex Chambers Trubach.
Good morning, Your Honor.
We've prepared a roster of our roles for your convenience. Would Your Honor like a copy?
Yes, thank you.
Permission to approach the bench and opposing counsel?
Yes, please. Are any housekeeping matters you'd like to attend to before you begin?
Yes, Your Honor. The people have two pretrial matters to attend to. The people request that all witnesses, with the exception of the defendant, Carmen Erickson, be constructively sequestered for the duration of this trial.
No objection.
No.
So ordered.
Our second motion is that we be allowed to move freely about the wells for the duration of our examinations. Nothing further.
Your Honor, is it the court's preference that counsel ask Your Honor's permission before approaching the bench, opposing counsel, or a witness?
This is the first time.
Yes, Your Honor. Additionally, we prepared copies of the party stipulated facts for the court's convenience. Would Your Honor like a copy of those as well?
Normally, I would say I hadn't, but since you took the time to prepare it, I will take it.
Yes, Your Honor. Permission to approach.
Please apply.
The defense would request a 5-minute recess between the prosecution rests the case and when the defense raises theirs, and an additional 5-minute recess for closing statements.
Go object, sir. Go object. And please hold me to that. Sometimes I can dance. Anything else for you again?
No, Your Honor. Now the defense is ready to begin.
The people are ready. Thank you. You may proceed. Open statements.
May it please the court. Even the best laid plans can fail. But the plan you will hear about in today's case wasn't even a good one. This case is about two best friends, Corbin Erickson and Carson Potter, who steal used cooking oil from Big Bird's barbecue pit, also known as the Bird Pit. My name is Sean Hall, and along with my co-counsels, William Miller and Elijah Hall, we will be representing the prosecution in today's case. As prosecution, we recognize that we will show beyond a reasonable doubt that the defendant, Corbin Erickson, committed petty larceny by stealing used cooking oil from the Bird Pit, and that she resisted a lawful arrest. Per penal law section 155.25, a person is guilty of petty larceny when they steal property. And for section 205.30, a person is guilty of resisting arrest when they prevent or attempt to prevent a police officer or peace officer from effecting an authorized arrest. Now, Your Honor, you may be thinking, why steal used cooking oil? The answer is actually quite simple. Financial needs. We expect to hear from the defendant himself, Corbin Erickson, who we anticipate will describe how he and Carson Blocker, who is named to testify today, were both unemployed, didn't have a steady income, and even struggled to make ends meet. Another question that may arise is, why the burn? The answer to this question stems from how Carson Blocker, the defendant's best friend, was fired from the burn pit by the owner, Gail Burns, who testified today. Listen how Blocker used to work with the used cooking oil in new details only an employee could know. Also, pay close attention how Erickson was upset by his best friend's firing. We'll see how financial needs, combined with history, led to a planned act of revenge. But when this plan was actually set into motion, it failed right from the start. When the two friends were at the bird pit on the night of August 31st, 2025, they did not expect for Gail Burns to return and catch them in the act. When Burns flashed their bright flashlight, they both immediately started to flee. Listen how one of the friends rips their jacket, and the other one was seen by yet another eyewitness getting into a driver's side of a truck. And this eyewitness will be Terry Johnson, who testified on stand today. We anticipate for Johnson to describe how she saw Corbin Erickson and another individual enter a truck and speed away from the burn on the night of the crime. Defense may question Johnson's credibility due to her past history with the defendant. However, they will not be able to explain how Johnson knows such specific details that correlate with multiple witnesses. Prosecution's final witness will be Chief Investigator Sal Thomas, who we anticipate will describe what led to obtain an arrest warrant for Corbin Erickson. Listen how Erickson had access to a pickup truck that matched the one seen at the crime scene. Pay close attention how in terms of affecting her arrest warrant, she said 8 Corbin and 2 are under arrest. We expect her comments to describe how Erickson struggled with the deputies. And listen to how the defendant himself, Mr. Erickson, will not be able to contest this point. We also have to hear from Billy Stewart. The defendant's cousin, we anticipate will offer an alibi, saying how all 3 friends were playing a video game on the night of will not show that Erickson was actively playing this game when the crime occurred. Also, Your Honor, listen to how Billy Stewart, the alleged alibi witness, is in debt to the defendant, Carmen Erickson. Your Honor, today defendants will want to look at every way they can fill in complete isolation. But when every single clip is corroborated by multiple witnesses, you will see just why Erickson's plan failed. It won't be a truck, it will be the truck. It won't be a jacket, it will be the jacket. And it certainly won't just be a thief, it will be the defendant, Carmen Erickson. Prosecution is certain that we will be our verdict. At the conclusion of this trial, we will come up and ask you to find Carmen Erickson guilty of petty larceny and resisting arrest. Thank you.
Yes, Your Honor. Permission to proceed? Thank you, Your Honor. May it please the court. Rather than presenting with a carefully reasoned investigation, the prosecution just told you a story that is as slippery as oil. Every time you try to pin down a concrete fact that points to my client, it slips away. Today, you'll meet A. Carmen Erickson, a young man who spent the past few years working tirelessly to better himself and stay out of trouble. On September 9th, 2025, Carmen was enjoying a night out, shooting pool with a friend. That same night, his world fell out from under him. Not because of anything he did, but because of a rushed investigation based on a lie. You'll hear that the pool hall was in a notoriously crime-ridden neighborhood. And as Carmen will tell you, when he left that hall, a voice hidden in the dark screamed at him and called him names. Now Carmen couldn't see who was shouting and wasn't told he was under arrest. So like any reasonable person would, he ran. It was only when the police caught up that Carmen realized he was being arrested and not mugged. He was detained overnight and wasn't told until the next day that he was to be charged with resisting arrest and petty larceny. Now I want to take a moment to talk about the law requires for conviction. The prosecution, and only the prosecution, bears the burden of proof today. They must prove both elements of both charges beyond a reasonable doubt. The highest standard in the U.S. court system. That means that after hearing all of the evidence, you are not firmly convinced that there's no reasonable explanation other than guilt. The law requires that you find Carmen not guilty. So let's talk about the first charge, resisting arrest. To prove that Carmen resisted arrest, they must first prove that he tried to stop a lawful arrest, and second, that he did so intentionally. They can't meet that burden because Carmen was never told that he was under arrest. He could not have intended to resist an arrest that he didn't know was happening. For the second charge, petty larceny, they must prove first that Carmen wrongfully took property, and second, that he did so intentionally. They can't meet these burdens either because they can't pin down definitive evidence tying Carmen specifically to that fact. Now, these just told you their slippery story, but let's take a moment to now talk about the facts. On the night of the theft, Carmen stayed in all night playing games with friends. Carmen's cousin and gaming buddy will confirm that testimony. She'll tell you exactly when Carmen logged onto the game early in the night, and that he logged off long after the crime had been committed. Next, you'll hear from Carmen's old probation officer, who will tell you about the years of work that Carmen put in to learning to make the right decisions, to staying out of trouble. Now, on the prosecution side, the restaurant owner may claim to have seen the crime as it happened, but also won't be able to identify a single physical feature of either of the thieves. In fact, Your Honor, the prosecution's only so-called eyewitness has harbored a grudge against my client for over a decade, and will admit she wasn't even sure it was my client that she saw. are certain of where Carmen was that night, but the prosecution will try to tell you that one biased witness who wasn't even sure of who she saw proves beyond a reasonable doubt that it was my client. So let's take a moment to cover all of the facts we'll hear for today. 1. Sometime on the night of August 31st, there was a theft at the burn pit. 2. Carmen stayed home all night playing games. That is all we know. Anything else that been slipped in by the prosecution is part of a slippery story that doesn't even point to Carmen. Don't let the prosecution's careless rush to convict take away Carmen's future. Today, you'll see for yourself that the prosecution's story is as slippery as oil. And at the end of today's proceedings, my co-counsel, Calder White, will ask that you find Carmen Erickson not guilty. Thank you.
Prosecution would like to call Gail Burns to the stand. Your Honor, before you did, may I approach to have this evidence marked for identification?
Yes. You should have to do all the time.
Can you mark these as exhibit 1, please? And let the
Exhibit 1, marked for information.
and let the record reflect that I'm trying to copy the opposing counsel.
You may ask.
Good afternoon, Ms. Burns. Can you please introduce yourself to the court?
Hi, my name is Gail Burns. I'm 51 years old and I reside at 1776 Civic Circle.
What do you do for a living?
Well, I'm the current owner of the Big Burns Barbecue Pit, or as we like to call it in Butler, New York, the Burn Pit.
How long have you owned the burn pit?
Well, I guess it's been about 20 years now.
What are the typical hours that the burn pit is open?
We are open from 11 a.m. to 1 a.m. every day except on Mondays.
How is the burn pit doing financially?
We do okay, but
Overall,
Would you like me to ask a question?
yes.
How is the burn pit doing financially?
We do okay, but it's not like running a high-end restaurant. We're a barbecue joint. The business is competitive and profit is small.
So, directed your attention to the night of August 30th and to the early morning hours of August 31st, 2025. What happened that night?
That was the night 2 thieves broke into my restaurant and stole my used cooking oil.
Do you recall what time you closed up your restaurant?
Yes, we closed up at 1 a.m. The employees left around 1:10, and I probably locked up and went to go later than that.
Where did you go after closing up your restaurant?
I went home. I live close by.
And what happened then?
Well, I realized that I had forgotten to set up my restaurant's alarm system like I normally do every night.
So, what did you do?
I went back to the restaurant to set it up.
Do you recall what time you got back to the restaurant?
Yes, around 2:15 a.m.
And what happened when you got there?
As I was headed to the front door, I heard some noise coming from the back of the building.
Did you investigate these noises?
Yes, I took my flashlight and headed to where the noise was coming from.
And what did you see?
I saw 2 individuals there in an old pickup truck.
Anything else?
Yes, I saw 4 50-gallon storage drums in the back of the pickup truck with a siphon drum pump attached to one of them.
Now, how did you react to seeing this?
I couldn't believe it. I mean, the one night that I forgot to set up the restaurant's alarm system, people break into it.
So, what did you do when you saw these 2 individuals appearing to steal from you?
I yelled at them to stop.
How did they react?
They got the heck out of there. I could be pretty scary sometimes.
Did you know who either of the 2 individuals were?
No.
Were you able to get a good look at them?
Well, they only turned for a quick second before they ran away from me, so I didn't even get the chance to.
Were you able to see anything distinguishable about you and the two individuals?
Yes, one of the thieves had on a jacket.
What, if anything, did you notice about this jacket?
I noticed the jacket got stuck on a nail and ripped.
And what happened then?
Well, the thief with the ripped jacket headed to the passenger side of the truck before they sped away.
Did you get a good look at this truck?
Like I said, they sped away, but I did manage to get the number 8 on the license plate.
Now, Miss Burns, were you ever able to determine what had been stolen from your restaurant?
Yes.
What was stolen?
Well, before I had left that night, we had 3 full 75-gallon storage bags of used cooking oil, but when we came back, 2 of them were completely empty and the third one was nearly empty.
Why do you keep so much used cooking oil?
I sell it to the contractor.
How often?
Well, my contractor comes and picks it up the first of every month.
To the best of your knowledge, how much was the stolen cooking oil worth?
The price varies month to month, but if I had to give my best estimate, I would say a little over $140.
Now, do you know Carson Blocker?
Yes.
How so?
Carson is a former employee of mine.
What do you mean by that?
Well, she worked for me before I fired her.
And do you know the defendant in today's case, Carmen Anderson?
Yes.
How so?
Carmen would always come in while Carson was working and distract her.
Why did you fire Carson Blocker?
Well, honestly, it was as much about Carmen as it was about Carson.
What do you mean by that?
Well, they would always goof around in their matching jackets, and Carmen would always try to make Carson leave work early and things like that.
Right, but what was the actual reason that you fired Carson Blocker?
Well, the last straw was when there was a 45-gallon oil spill because Carson was getting distracted.
Now, you mentioned earlier jackets. Were these matching leather jackets?
Yes.
Your Honor, may I approach the witness?
Yes.
I'm handing you Mr. Marks Prosecution Exhibit 1. Can you tell me what this is?
Yes, it's a leather jacket.
Whose leather jacket is this?
It's Carson Blocker's.
How do you know that?
Well, I would always see Carson wearing it around work.
And are you sure it's the same leather jacket?
Yes.
Your Honor, at this time, we move Prosecution Exhibit 1 to evidence. Pursuant to Stipulation 7, both parties have agreed that this is the actual jacket worn and seized by investigator Sal Thomas and worn by Carson Blocker.
Any objection?
No objection, Your Honor, so long as this jacket is understood to be solely the jacket that Ms. Burns saw Mr. Blocker wear to work and not the jacket that she saw on the night of the theft.
Yes, I'm a Your Honor.
And that's received.
Now, looking at this jacket, do you notice anything different about it than you saw last time?
Yes, there appears to be a large rip that's been repaired.
Have you seen this rip before?
No.
Thank you. You can give me evidence. Now, Ms. Burns, when did you fire Carson Blocker?
July 16th, 2025.
And the oil that was stolen, when was it scheduled to be collected?
September 1st, the next day after the crime.
And on the night of the crime, how long had you been gone before you came back and caught the two thieves in the act?
A little less than an hour.
One last question, Ms. Burns. Who worked with thieves cooking oil?
Until I fired her, Carson Blocker did.
Thank you, Your Honor. No further questions.
Yes, Your Honor. Bishop, proceed. Ms. Burns, I'd like to start by talking about your relationship with my client. Carmen used to come to the birthday.
Yes.
And as you mentioned on direct, he would speak with one of your employees, Mr. Blocker.
Yes, he would.
You fired Mr. Blocker in July of 2025.
Yes,
You fired Mr. Blocker after an oil spill.
that's correct.
And you believe that Mr. Blocker caused this oil spill because he was distracted by work.
Yes,
You believe he was distracted by Carmen.
I do.
And ever since then, you've deeply disliked my client.
Well, they weren't very hard workers.
Right, so let's talk about some of the things that you would call my client. You think that Carmen and Mr. Blocker are bad trouble.
Yes,
You think that they cause mischief.
yes.
You would characterize them as gangsters.
They always wear the matching leather jackets.
So yes to my question, you would characterize them as gangsters.
Yes,
Now I'd like to move to August 31st. That night, you closed your restaurant a little after 1,
yes,
and you returned around 2:15 a.m. You heard a noise coming from the back,
Yes,
so you went to investigate.
of course.
And you brought your flashlight with you.
I did.
This flashlight was bright enough to light up the whole street.
Yes.
So let's talk about what you saw when you got there. You saw a pickup truck.
I did.
You saw oil drums in the bed of the truck.
Yes.
You saw a drum pump.
Yes.
And you believe the theft was occurring.
Yes.
So you yelled at the thieves to stop.
Of course.
The thieves turned back to look at you.
For a quick second before they turned to run away from me.
So that's a yes to my question. They turned back to look at you.
Before they ran away from me, yes.
And you didn't recognize them.
Well, I didn't get the chance to. They were running away from me.
That's a yes to my question. You didn't recognize them when they turned back to look at you.
I didn't get a good look at their face, so no, I did not recognize them.
You can't tell us their gender.
I did not get a chance to recognize them.
That's yes to my question. You can't tell us their gender.
No, I cannot.
You can't tell us their height.
No.
Objection, Your Honor, calls for invention of fact.
Your Honor, can you respond?
Yes, we do.
Your Honor, this question does not call for invention of fact because pursuant to Local Rule 702, it does not elicit information outside of what is contained in Ms. Burns' fact pattern. Both in her affirmation and on direct examination, Ms. Burns testified extensively to the details of what she saw on the night of the theft, including seeing a jacket and details as small as seeing an 8 on the license plate. The fact that Ms. Burns did not state any other details about the night of the crime in her affirmation amounts to a material omission. Pointing to a material omission does not call for Ms. Burns to invent facts. Had Ms. Burns seen other details about the night of the crime, it would have been stated in her affirmation, and she would have told you about it on direct examination when she swore to tell you the whole truth.
Any response?
Yes, Your Honor. That may be so, but nowhere in this witness's affidavit do they say that they did or did not know the height of this person. So asking to say if they did or did not know would be inventing a fact.
Your Honor, may I respond?
Rick?
Your Honor, precisely what opposing counsel said, Ms. Burns did not contain this information in her affirmation because she does not know it. And furthermore, Your Honor, this is cross-examination. Ms. Burns is free to say any answer that does not materially alter the outcome of the case. She can say she didn't see it, she can say she doesn't know, or she doesn't remember.
Okay. Very good arguments on both sides. Overruled. Membership.
Would you like me to re-ask the question? Sure. You couldn't tell us their height.
It is not stated either in my affidavit, so I cannot answer that question.
So it says you can't tell us their height?
Yes, I cannot.
Now, you did see one of their jackets snag on you.
Before it rips, yes, I did.
Right, you heard the jacket rip.
Yes.
But you didn't see it rip.
No, sure.
You can't tell us what kind of jacket it was.
I wasn't looking to critique their fashion sense. I was trying to get them to stop stealing from me.
But just for example, you can't tell us what color the jacket was.
Like I said, I was looking for what type of jacket they were wearing. I wanted my restaurant to be stopped being stolen from.
And aside from the snag of the jacket, you can't tell us a single other physical characteristic of either thief.
A lot was going on. My restaurant was just being stolen from. I was not looking for the characteristics of whoever's stealing from me. I just wanted my restaurant to be stopped being stolen from.
Thank you for that, Ms. Burns, but I'm not asking about what you were thinking. I'm asking about what you saw. And you did not see a single other physical characteristic of either thief, correct?
No, I did not get a chance to.
Thank you, Your Honor. No further questions.
No redirect, Your Honor.
Thank you, Mr.
The prosecution calls Terry Johnson to the stand. Can you please introduce yourself to the court?
Yes. Hi, my name is Terry Johnson. I'm 27 years old, and I live in Butler, New York.
What's your address, Ms. Johnson?
I live at 1616 Lincoln Avenue on the second floor.
Are you familiar with the Grand Barbecue Pit?
Yes, I have a great idea of what I'm
Directing your attention to the morning of August 31st, 2025. What were you doing at around 2 a.m.?
At around 2 a.m., I woke up to get a glass of extremely bright light shining through my bedroom window.
How did you react to seeing this bright light?
Well, it was extremely abnormal, so I decided to go to the window and investigate.
And after looking outside your window, did you see anything?
Yes, there was a pickup truck backed up to Gilbert's restaurant and burned it.
Did you see any individuals?
Yes, I saw two individuals. One was entering the driver's side and one was entering the passenger side of the truck.
Did you see these individuals doing anything else?
After they got in the truck, they sped away.
And did you recognize either of those individuals?
Unfortunately, I didn't get a good look at the passenger, but I did recognize the driver.
And who did you recognize the driver to be?
The defendant was Kurt Erickson.
Let's talk about the defendant in this case. How do you know Mr. Harris?
I've known him for a long time now, since middle school.
Approximately how many years is that?
Well, I'm 27 now, so well over a decade.
And did you and Mr. Erickson go to the same middle school?
Yes, we did.
But did you and Mr. Erickson go to the same high school?
No, we did not. My parents moved my sister Stacy and I to another school district when I finished my 8th grade year.
Let's go back to August 31st, 2025. What happened later that day?
Later that day, I was on a run through the park when I overheard some of my neighbors talking about a crime that had been committed the night before.
Did you go on to talk to any neighbors?
Yes, I did.
And what did you and this neighbor discuss?
We discussed that used cooking oil had been stolen from Gilbert's restaurant in Burn Pit at around 2 a.m. on the morning of August 31st.
And how did you react to hearing this information?
Well, considering everything that I had seen that morning, I decided to call the police.
After calling the police, did you meet with any of the authorities?
Yes, Chief Investigator Sal Thomas visited my apartment on September 3rd.
And what did you and Investigator Thomas discuss?
We discussed everything that I had seen that morning, from who I had seen to what I had seen occur.
And who did you tell Thomas you had seen?
I told the investigator that I saw the defendant, Harvey Erickson.
After that meeting with Thomas, did you meet with Thomas yet?
Yes, she returned to my apartment on September 4th.
Did Thomas bring anything with him?
She brought a photo array.
Did you select a picture from this photo array?
I did. I went right to one photo with no hesitation.
Why without hesitation?
Because it was a person I had seen that morning.
And who was the person in that picture?
The defendant, Harvey Erickson.
No further questions.
Thank you.
Good morning, Ms. Johnson.
Good morning.
I'd like to start by talking about what you were doing in the early morning of August 31st. As you testified in your draft, you were up around 2 a.m. that night.
Yes, I was.
You noticed a bright light outside.
Yes, after returning from my kitchen, there was an extremely bright light shining through my window. As mentioned on direct.
You looked out the window to investigate,
Of course, it was extremely abnormal.
and you noticed commotion behind the burn.
Yes, I did.
So let's talk a little bit more about what you saw there. Now, you testified that there was a vehicle behind the burn pit, correct?
Yes, there was a pickup truck backed up to the back of the restaurant.
So the vehicle, the front of it, was facing towards you.
Yes, it was.
You saw 2 people by that truck, right?
I did. I saw one getting into each side of the truck.
Well, let's start by talking about the person on the driver's side. And Ms. Johnson, you weren't 100% sure who that person was, correct?
That would be correct. I definitely didn't think it looked like Harvey Erickson, and I also wasn't 100% sure that it was a crime at that time.
To be clear, Ms. Johnson, you only thought that this was a person who might look like Harmon Harrison, right?
Correct. I absolutely thought that person looked like Harvey Erickson.
You only got a quick glimpse of that person.
That would be correct, but it doesn't have to be long to do their look.
Now, there's another person on the passenger side of the car, correct?
Yes, there was.
And you can't tell me a single one of that person's physical features.
Objection, Your Honor. Calls for an intervention of fact.
Your Honor, pursuant to your previous ruling, this question does not call for an injection of fact, because pursuant to local rule 702, it does not seek to elicit information out of what is already contained in Ms. Johnson's fact pattern. She testified under direct extensively about what she saw that night, and she swore in her affirmation to tell you the whole truth and nothing but the truth. The fact that Ms. Johnson did not describe physical features of the other person makes it clear that she does not, in fact, know any physical features of that person. Furthermore, it is a cross-examination. If she doesn't know the answer, she is forced.
Your Honor, you can't hear it. This information is not contained in this solicited affidavit, and due to this being a mock trial, witness can only testify to what's in the affidavit and what's not in the affidavit. And, Your Honor, this is not contained in this affidavit.
Well, arguing both sides, this is an academic exercise, I'm over your objection.
Could you please just ask the question?
You can't tell me a single physical feature of the other person considering that the person that I had recognized was the driver, I was much more focused on that identification as I would be more confident in it. So no, I did not recognize the passenger.
In fact, you couldn't tell me what either person was wearing, right?
Not necessarily, I was much more focused on their faces. That is the most identifiable feature.
And Ms. Johnson, you recognized that the vehicle was a truck, correct?
I did.
And you can't tell me the color of that truck.
Again, that's not what I was focused on.
Now, I want to talk a little bit more about what you did when you woke up the next morning. On the day of August 31st, you heard there was a theft at the burn pit, right?
Yes, I heard from a neighbor later that day.
You heard it happened around 2 a.m.
I did.
And that was the time that you were at your window, correct?
Yes.
And on August 31st, you didn't reach out to the authorities.
Not necessarily. Considering I was not 100% sure on who I had seen that night of, I decided to take a little bit more time to become increasingly confident in who I had seen, as accusing someone of a crime is a no-lie accusation and it shouldn't be handled as such.
Ms. Johnson, you also didn't reach out to the authorities the next day either,
No,
correct?
as I just stated, I reached out on September 2nd.
And you needed those few days to convince yourself it was Carmen Erickson you had seen, right, Ms. Johnson?
Correct. As I just stated, I wanted to be absolutely confident in what I had seen.
So you finally met with the investigator on September 3rd.
That would be correct.
And you told that investigator that you were willing to do anything and everything to put Carmen in prison, correct?
Absolutely. I wanted the investigator to understand that I wasn't afraid to testify against my middle school bully.
You also told that investigator it was definitely Carmen Erickson you had seen.
Yes, I did. By the time that I informed police, I was definitely sure of who I had seen that morning.
And then the investigator came back the next day.
She did.
This time to show you a photo array.
That would be correct.
She asked you to point out if anyone in the array looked like someone you had seen on the night of the theft.
Correct.
And Ms. Johnson, as you testified in your direct, you went straight to the photo of Carmen, right?
Absolutely. I went straight to the photo of the person that I had seen the morning of August 31st.
Johnson, you didn't stop to consider the other options.
I didn't need to. I saw the person that I saw, and that is who I identified.
And Ms. Johnson, you believe that your identification was used to issue an arrest warrant for Carmen.
That is what I was informed of, yes.
And hearing that was music to your ears.
Absolutely. I was extremely grateful that I was able to help the investigator keep crime off the streets of my community.
In fact, Ms. Johnson, it made your day.
Again, I was extremely grateful that I could help this investigator keep crime off the streets.
Now, I want to talk about your personal relationship with my client. You met Carmen Erickson in middle school, right?
I did.
But you didn't go to the same high school.
We did not. As I stated on direct, my parents moved my sister Stacy and I to another school district.
But you're not friends with Carmen now.
I am not.
You're now 27 years old, Ms. Johnson.
That would be correct.
And to this day, you think of Carmen as an awful person.
Well, considering I don't know Carmen anymore, I only know how I knew of her in middle school, and at that time, yes, I would say she was an awful person.
Ms. Johnson, is that a yes to my question? That you think Carmen is an awful person?
As I just stated, yes. And according to my knowledge from middle school, it would be yes.
You think Carmen is a bully?
Again, I only know her from middle school, and at the time of middle school, she was in fact a bully.
Ms. Johnson, you think that Carmen is finally going to pay for his misdeeds?
Well, considering everything that has occurred in this trial, I would hope that Carmen only pays for everything that she's done to this community.
You think that his payment has been a long time coming?
She did punch my sister in the jaw in middle school. I wouldn't say that that has any correlation to this, but in that terms, yes.
You have moved to strike the line for Mr. Statement as impermissible use of past crimes on his status.
Like you heard?
Oh, yeah. Then the last part of the signature.
Ms. Johnson, you couldn't wait to testify against Carmen, could you?
As stated, I wanted the investigator to know that I wasn't afraid to testify, so yes.
Ms. Johnson, you are thrilled to play a part in the demise of Carmen Erickson, right?
You can say that. I was definitely grateful to help the investigator.
Ms. Johnson, not a yes to my question. You are personally thrilled to play a part in the demise of Carmen Erickson.
As I just stated, yes, I am extremely thrilled to help keep crime on the streets of my community.
Thank you, Your Honor. No further questions.
Reader?
Oh, yeah.
Thank you.
Thank you, Your Honor.
Exhibit 2 and 3, marks for identification.
Ready? Now, can you please introduce yourself to the board?
My name is Sal Thomas. I'm 44 years old, and I live in Butler, New York.
And can you tell us what your educational background is?
I graduated from SUNY Butler State College in 2003 with a degree in criminal justice, with significant coursework in constitutional law and forensic evidence collection. I then attended the Cook County Police Academy.
So then, what is your profession now?
I am the chief investigator for the Robert Garson Battalion in the Cook County Sheriff's Department.
And how long have you had this profession?
I've been a police officer for 21 years. I've been an investigator for 7 years, and I've been chief investigator as head of my department for 5 years.
And are there any particular types of crime that your department is focused on?
Yes, there have been an increase in larcenies on businesses within the past couple of years, which my unit has been focused on.
Your Honor, at this point, we'd like to submit Investigator Sal Thomas as an expert in investigation to discuss the goals of all the persons.
This is Lawyer Ms. Thomas, your investigation did not require you yourself to conduct any scientific or tasks or review any scientific data, correct?
That is correct.
You interviewed witnesses and visited the scene of the crime,
I did.
and you informed your opinions based on what you reported to the witnesses as well as things you observed yourself.
That is correct.
Your Honor, pursuant to local rule 502, experts may only provide opinion testimony on subjects that require technical, scientific, or other specialized knowledge. Ms. Thomas has just testified in a way that makes it clear that her testimony will not help the trier of fact understand any esoteric information. Therefore, her entrance as an expert is not warranted.
Your Honor, if I may respond? Well, the opposing counsel has asked any questions, but one of the officers in this case has done this investigation. It failed to talk about the prior investigations and experience this officer had. As such, there is no ground case for how this investigator has not previously worked with investigations on scientific material. And due to that, there is not a prior foundation established to have this witness who is not an expert in such matters from his career. As such, and pursuant to the fact that we're only submitting her as an expert in investigations, which she has a wealth of experience on, we believe that she showed the fact that he has an expert in investigations.
Any further? Opposing counsel has argued that Ms. Thomas's experience looking at scientific data in past cases warrants her entrance as an expert in this case. That argument does not make sense because Ms. Thomas has testified that in this case specifically, she didn't analyze any specific or technical evidence. She's merely been testifying to things she observed herself in the course of her investigation and witnesses she spoke of. Therefore, according to the rule I said earlier, her entrance as an expert is not warranted because there is no expertise required to help explain any conclusions she may have.
Your Honor, if I may respond? Yes. We are planning to use her. We are planning to use the investigator stage to be able to use the expertise she's had in the past as well as what she currently has in order to make necessary conclusions that would meet expert opinion within the investigation and within that background. Subject to that, and I apologize, we have not laid a foundation. She's not worked with this in the past. We still believe that she needs that an expert in this case.
In all defense to the expert, so qualified as an expert in crime scene investigation. Your objection is noted.
Now, are there any particular types of larceny that you are focused on?
There have been 27 cases from January to August alone relating to the theft of used cooking oil. These cases are a priority because they are difficult to solve and they have been increasing in frequency.
Now, you mentioned that they are difficult to solve. Would you mind sharing why you say that?
This is because partly the restaurants use cheap alarm systems which are easy to evade, and partly because the crimes occur at night when the restaurants are closed.
Now, moving your attention to the morning of August 31st, can you tell us what happened?
Around 2:30 a.m., the sheriff's department got a call from the burn pit about the alleged death of these curfew women. I arrived on scene with the responding officers.
Now, was there anything different about this particular crime?
While rarely with crimes like these there are eyewitnesses, with this particular case there were two.
And who were these two eyewitnesses?
Gail Burns, the owner of the restaurant, and Terry Johnson.
And can you tell us what you did with the evidence you gathered from these two eyewitnesses?
With the evidence that I gathered from these two eyewitnesses, I was able to obtain an arrest warrant for Carmen Erickson.
And what did you do with the arrest warrant?
On September 9th, 2025, I executed the warrant in a public place, specifically outside Queen City Saloon and Pool Hall.
Now, you mentioned doing so in a public place. Would you mind sharing why you chose to do that?
In my experience, confronting a suspect in a public place by surprise diminishes the threat to bystanders, to my fellow officers, and to the suspect themselves.
And could you tell us what happened during the arrest?
Erickson exited Pool Hall with Blocker, and I announced, "Hey, Carmen Erickson, you are under arrest."
So, what was their response?
Well, Blocker fled, and Erickson struggled with identities.
And was there anything distinctive about their appearance when you arrested them?
Yes, both Blocker and Erickson were wearing matching leather jackets. Blocker's had about a 5-inch rip in the back of it that appeared to have been repaired.
And did you recover evidence pursuant to this arrest?
Yes, Carmen Erickson had his cell phone on him, so I obtained a warrant to search it for potential evidence.
And what did you find on Erickson's phone?
I found a video of Carson Blocker wearing that leather jacket.
May I have those words?
Amen.
And he would have been informed as people student. Now, can you please identify this item?
This is a screenshot of the video of Carson Blocker wearing their leather jacket.
And where was this video found?
It was found on Carmen Erickson's cell phone.
And when was it produced?
It was produced on August 21st, 2025, which was 10 days before the night in question.
Objection here, is that may I Your Honor? The defense has a good faith basis that this witness's conclusion that this document was created on that date is based on a statement contained on the document stating that the document was created on August 21st. This testimony is therefore hearsay and is inadmissible.
Respond, Your Honor. Nothing about today's testimony suggests that that is the reason for this particular document. I believe the proper foundation has been established and how this witness would know this fact, and none of it goes through a particular statement on that document. If the opposing counsel wishes to redact the document when presenting evidence, I believe it has to be in there. However, as of right now, I believe there's a necessary foundation has been established as to how this witness would know this, which is not the case.
May I respond, Your Honor?
Yes.
In that case, I would change my objection to lack of foundation. Assuming the witness is not saying that they knew that this document was created on August 21st because they read that the photo said it was created on August 21st, this witness has not explained how they came to determine that the document was produced on that date, and therefore they do not have sufficient foundation to testify to that.
If I may respond, Your Honor?
Yes, great.
Of course. The witness sort of agrees to testify that having found the search warrant and looked through the photos, that is the foundation.
Unallowed subject to further connection.
Now, is this one of the documents you reviewed within your investigation?
It is.
And to the best of your knowledge, a true and accurate copy?
It is.
Your Honor, at this point, we enter prosecution 2 with evidence.
You renew your objection.
Yes, Your Honor, and I ask that the date at the bottom of the photo be stricken as hearsay.
We have no objections, Your
Okay. Then proceed with that redaction.
Honor. Now, looking at this image, is the jacket ripped?
No, the jacket is not ripped. It appears to have no tears.
You can return that. Now, moving on, can you tell us what happened after the arrest?
Billy Stewart, the defendant's cousin, reached out to me.
And what did Billy Stewart? When did Billy Stewart reach out?
September 17th, which was a week after the defendant was arraigned and released.
And what did Billy Stewart say?
Billy Stewart said that she and Carmen Erickson and Carson Blocker had been playing video games on the night of the event.
So, what did you do with this hour?
I ran it down. I contacted the video game headquarters to see what they could share with me in order to verify this alibi.
And what did they show?
They shared with me several things, such as the game logs, and they explained to me how they worked.
Members, any questions? Can you please identify the document?
These are the game logs.
And tell me, who produced this document?
The League of Vendors headquarters.
And when was it produced?
On September 18th, 2025.
Is this one of the documents you reviewed within your investigation?
Yes, it is.
In possession of a true and accurate copy?
It is.
Your Honor, this one we three.
Objection, your Honor.
Members, while this particular document is admissible under Rule 404, business records exception, in this particular case, if the opposing counsel can stipulate this document supporting their alibi as hearsay, we would have to delay.
Your Honor, this document does not qualify as a business record. This witness cannot testify to the regularity of the record-keeping operations at the Legal Vendors headquarters. Therefore, this document is hearsay.
Your Honor, as I just said, we have no problem with stipulating this is hearsay, so yeah, in this case, we will not have that.
You're not offering?
Not offering.
Okay.
Now, have you learned anything else? Did you ever talk to Lewis again?
Yes. Over the course of my investigation, I learned that Mr. owns a truck. So I visited her at her apartment to ask about it.
And what did you learn about this drug?
I learned that it matched the physical description given by the eyewitnesses, including the license plate number.
And you learned anything else from what you learned?
Yes, I learned that the defendant, Carmen Erickson, has access and permission to use this drug.
Objection, your Honor.
Respond. This is admissible under the effective listening exception. We're not offering the truth matter, just to show how effective investigator Sal Thomas's investigation moving forward.
Apologies, Your Honor. If this testimony is being offered for the effective listener, I ask that opposing counsel specify what the effective listener is, and if they're unable to do so, you should have an objection to relevance.
Well, I'm going to do this, I'm going to overrule the objection, but of course you have double ground on cross-examination of the story.
Yes, sir.
Would you react to the question?
Yes.
Now, can you tell me what else did we see? What else you learned from questioning the story?
I learned that the defendant, Carmen Erickson, has access and permission to use the drug.
Now, how did learning of these facts about the truck affect your investigation?
With this information and the other evidence I have received over the course of my investigation, pointed to Carmen Erickson as the suspect.
Thank you, Your Honor.
Yes, sir. Any fire? Good afternoon, Ms. Thomas. From restaurants.
Yes,
You receive 3 or 4 such calls every month.
we do.
In between July and August of last year, you received 27 such calls.
Between July and August?
Between January and August of last year, you received 27 such calls.
That is correct.
Despite the widespread nature of use with neural effect, in this case, you would investigate anyone besides Carmen.
It is not mentioned in my affidavit, no.
So in your affidavit, you don't mention considering anyone else as a suspect in this case?
Other than Carmen Erickson, we had considered Morris Walker.
But other than those two, in this case, there was no one you considered as a suspect.
No, that is correct.
For example, you never considered Miss Billy Stewart a person of interest.
We outruled Billy Stewart as a suspect.
That's a yes to my question. They were never considered a person of interest.
They were outruled as a suspect, so they were, but then we...
Is it your testimony that at one point in this investigation they were considered a suspect?
It is my testimony that in my sworn affidavit, I stated that Billy Stewart had been ruled out as a suspect.
Returning to the many thefts you investigate, as you said on direct, in many of these cases, the systems with the businesses could not afford sophisticated security systems.
That is correct,
And the systems that they had were cheap and easy to defeat.
unfortunately.
That was true of the burn pit.
Yes.
And because of that, in this case, there's no surveillance footage.
Yes, that is correct.
Continuing on that theme, there's also no DNA evidence.
No, there's not.
There are no fingerprints,
Not that it is stated in my affidavit, no.
no tire tracks,
This information is not stated in my affidavit.
and you didn't recover any equipment that might have been used to steal oil.
Well, the empty oil bins were still on the scene of the crime.
Is it your testimony that when you arrived at the scene of the crime, you were able to recover empty oil bins?
It is my testimony that Gail Burns testified that there were two fully empty oil bins and a little bit of oil left in the third one.
To clarify, she told you that those oil bins were in the back of the truck that left, correct?
No, I'm referring to the oil bins that were stolen from within the restaurant.
But when you arrived at the scene, you were unable to recover those oil bins, correct?
That were in the trunk?
Yes.
Yes, that is correct.
One piece of evidence you did claim on direct to have is an eyewitness, correct?
Yes,
And this eyewitness is Ms. Johnson.
yes,
Ms. Johnson reached out to the sheriff's department to volunteer information, correct?
yes.
And when you spoke with her, you learned that she and Carmen had a bad relationship going back since middle school.
I would say they had a little bit of a history, sure.
Well, Ms. Johnson told you she truly hated Carmen.
She did say that, but I can't testify to the way that Terry Johnson truly feels.
She also told you she would do anything and everything to put Carmen in prison.
Like I said, she did say that to me, but I can testify to what she actually meant by that statement.
But she did say that to you.
She did.
And she also told you she had promised her sister she would make Carmen pay dearly.
She had something along those lines.
Is that a yes to my question that she said that statement to you?
Yes.
And after hearing all of this about Ms. Johnson's feelings towards Carmen, you heard all of that on September 3rd, correct?
Can you repeat that?
You heard all of this about how Ms. Johnson felt towards Carmen on September 3rd.
Yes.
And after hearing all of this, you returned the following day to show Ms. Johnson a photograph.
Yes.
Previously, Ms. Johnson had told you she wasn't 100% sure the person she had seen was Carmen.
On the night of the theft, but she also told me that she was more sure.
But that's a yes to my question that at one point she told you she was not sure the person she had seen was Carmen.
To be clear, this was on the night of the theft, but that is correct.
She told you that she later had to become convinced she had seen Carmen.
She convinced herself, yes.
Yet, when you showed her the photo array, she immediately chose Carmen, despite this initial hesitancy.
That is correct.
And that's someone she said she hated?
It was the person who she had seen that night.
But that's a yes to my question. She had told you that that person was someone she hated.
Yes.
And based on that identification, you secured a warrant for Carmen's arrest.
With this identification and other evidence we received.
But that's a yes to my question that you used that to obtain a warrant.
Yes.
Next, I want to talk about the jacket that Mr. Blocker was wearing at the time of Carmen's arrest. In the course of your investigation, you obtained a video of Mr. Blocker.
I did.
And in that video, Mr. Blocker's jacket is unripped.
It is.
You next saw Mr. Blocker 9 days after the crime occurred.
I did.
That was September 9th.
Yes.
And when you saw Mr. Blocker for the second time, you noticed that his jacket was now ripped.
Yes, and it's been repaired.
The original video had been taken 10 days before the crime.
That's correct.
But when you saw that their jacket had ripped, you believed that their jacket had ripped while committing a crime on August 31st.
Yes.
And you saw them in total 19 days after that original video had been taken.
Yes.
So you don't know where in that 19-day time frame the jacket ripped.
Not specifically, no.
Objection, Your Honor. The question is pointless to speculate on what exactly.
May I be heard, Your Honor? This witness has testified that the screenshot of the video that opposing counsel presented under direct examination, that in that photo they saw that the jacket was unripped, and that when they next interacted with this blocker on September 9th, the jacket was ripped. This witness has testified that aside from that 19-day time frame, they are unable to narrow it down further as to when the jacket ripped. This testimony is well within this witness's rational perception, and additionally it's cross-examination, so if the witness does not know, they are free to say so.
Yes, I was going to say over it was cross and you have time to connect it on a redirect. But go ahead. Well, we pretend like I didn't say that.
Briefly, This particular question is asking the witness to speculate on the exact moment of which this is done throughout this week period, which she's not able to do, only to clarify between the two. Given that's a hypothetical, I would reject speculation.
Overall, on cross-examination, you can clarify. You can clarify.
Thank you.
To clarify, you don't know when in that 19-day window the jacket ripped.
I would agree with that.
Well, you had a photo from 10 days before the crime,
Yes.
and in that photo the jacket's unripped.
Objection, Your Honor. Asked and answered. This is the exact same question. Testimony given, I believe, about 3 questions prior.
It sounds like he's just rephrasing the question so he can ask the ultimate question.
That's correct, Your Honor.
So I'm not
You next saw the jacket on September 9th,
Yes,
and in that, when you saw the next, the jacket was ripped.
that is correct.
There are 19 days between those dates,
Yes,
and though you obtained a report from another establishment, that report talked about when the jacket was repaired, not ripped, correct?
that is correct.
So, comparing the video stills to your live interaction with Ms. Walker, you were unable to say where in that 19-day time frame the jacket ripped.
Again, I wouldn't agree with that because as he just said, there has been a report on when the jacket was repaired. And in order for it to be repaired, it needs to be ripped. So I would not agree with that.
But Ms. Thomas, I'm asking about when the jacket ripped specifically, not when it was repaired. Aside, within that 19-day time frame, you cannot narrow it any further to when it ripped.
Like I said, in order for the jacket to be repaired, the jacket needs to be ripped. So I'm saying I do not agree with that.
The report showed that it had been repaired by the time it was collected 9 days after the crime, correct?
Yes.
Next, I want to talk about the trucks you spoke about under the records. Ms. Burns told you that the truck she saw contained the number 8 in the license plate.
Yes.
You contacted the DMV,
Yes.
and you learned that Ms. Stewart owned a pickup truck,
Yes.
and that that truck contained the number 8 in the license plate.
Yes.
Because of that, you are pretty sure that that truck was used to commit the crime.
Well, after I interviewed those
But that's a yes to my question, that the number 8 in the license plate, a single digit, makes you pretty sure that that truck was used to commit the crime?
No, that is not correct. That is not the only information used to verify that that truck was diesel.
Well, to clarify, you learned from Ms. Burns and Ms. Johnson that it was a blue pickup truck. Excuse me, just a pickup truck, correct?
Yes.
They didn't tell you what color it was?
No.
They didn't tell you the make of it.
This information is not included within my affidavit.
So the only information you used to determine that this truck, the one Ms. Stewart owned, was the one at the scene of the crime, was a single digit 8, correct?
Also, Ms. Stewart's connection to the defendant.
Well, looking specifically at the truck and its physical characteristics, it was the digit 8 that helped you determine that that was the truck that you believe was used.
Well, it was a connection, yes.
To clarify, Ms. Thomas, there are 4 digits in every license plate in this region.
I believe so.
And, as you would say, probably hundreds of vehicles in Cook County with license plates containing the number 8.
Objection, Your Honor. Speculation.
Your Honor, it's cross-examination. If the witness doesn't know, they're free to say so. Additionally, this witness has testified that they've been investigating larcenies for 22 years. It's well within their expertise and rational perception as to the number of vehicles in an area with a license plate.
Let me hear from the president.
If I may respond. Your Honor, the fact that she's had previous experience in investigation regarding all the larceny does not mean she knows the number of vehicles with the number 8 in the license plate within this particular area. As such, this statement is calling the witness to speculate on the number of vehicles within this particular area that needs to be required. She would have to wait prior closing counsel. We need to lay some sort of foundation how she knows this, which is currently not there.
Your Honor, I'll reiterate what I said before, that this is cross-examination, and if the witness doesn't know, they're free to say so. Additionally, this question is more so focused on the lack of effect that the knowledge that there were many vehicles containing the number 8 in the license plate had on the investigator, rather than the fact itself.
I'll allow it over.
And you're pretty sure this truck was used, even though, as you yourself would say, there were probably hundreds of vehicles in Cook County with license plates containing the number 8.
Well, I have said that, but I do not know if that's actually true.
But that's a yes to my question, that you feel pretty sure that this truck was used, despite your belief that there are many trucks in this region containing the number 8.
I do believe this truck was used.
Thank you, Ms. Thomas. Thank you, Your Honor. No further questions.
Any reader?
No reader. The prosecution has no further witness.
I'm waiting for you to have your word, you said you have no further witnesses.
Oh, no, prosecution.
Oh, okay, yeah, that's not right. Okay. I think we agreed that we were going to take a break. Yes. Okay. We're going to take 5 or 10 minutes, or what would you like to do?
5 minutes to the rest of the day.
Okay, then we'll take a 5-minute break.
All right.
Please be seated.
Thank you, please be seated.
Yes, that's all.
Please got the clocks, raise your right hand. Do you promise to tell the truth, whole truth, and nothing but the truth?
I do.
Please have a seat.
Commissioner Casey?
Yes.
Good morning.
Good morning.
Could you introduce yourself to the court?
My name is Foley Stewart.
Are you familiar with Carmen Erickson?
Yes, I am. He's my little cousin and gaming partner.
And why are you here today?
I'm just here to clear up this case. There's obviously been a big misunderstanding because I know Carmen didn't say it. I was gaming with him all night long on August 8th.
I want to talk a little bit more about that night. You see, we're even in Carmen. What do you mean?
We're all month together playing this really cool video game called League of Legends.
You and Carmen commonly play video games together?
Oh, all the time.
That night, what time did you log on?
Around 10:30 p.m.
What about Carmen? When did you log on?
He came on about 15 minutes after.
Do you and Carmen often play video games so regularly?
If I'm being honest, we have a bit of an addiction. Many times we've been playing through the night into the early hours of the morning. This time is no different.
And that night, did you and Carmen take any breaks?
No, we were really immersed in the game.
Objection, speculation, Your Honor.
I'm not over.
Returning to this game, League of Legends, that you played, were you and Carmen familiar with that game?
No, as seasoned gamers, we were looking for something new, and League of Vendors was perfect.
Did you and Carmen take any steps to better understand how that game is played?
Yes, we did in practice and to get a feel for the game before playing for real. We also used this thing called autopilot to show us how this game should be played. I would have been awesome at it.
And while you're on autopilot, who is winning?
You're looking at it.
Does that continue for the duration of the night?
No, at around 3 a.m. I'm doing games in the game.
Objection, relevance.
Your Honor, it's the defense's theory that because Miss Stewart and Carmen were both new to the game, the fact that Carmen began to win after 3 a.m. when they exited autopilot implies to some extent that you were watching the game you played and were therefore learning. It is the defense's theory that had Carmen left his apartment to see oil, it is more likely that he would have lost to Miss Stewart, who neither side disputes was in her apartment watching the game play.
Your Honor, Your Honor, it's not relevant as to the actions being taken on the game as to who was winning, Your Honor. That does not show if Erickson understood the game better. Erickson could have been better game in general, Your Honor. This question is not relevant.
May I respond?
I'm from the loud one here.
Well, in that case,
Oh,
I'll already asked the question. While you're autopilot, who is winning?
Me.
Does that continue for the rest of the night?
No, again, I'm just dancing later on 3 a.m. and doing that autopilot. Unfortunately for me, he was actually getting really good at the game. Only all that practicing in autopilot was better for me.
Next, I want to talk about any interactions you may have had with the prosecution's expert investigator on this. Did you and her ever speak?
Yes, we've spoken a couple times. The first was on September 17th, when I called to see what was going on about Connie's arrest. She then visited me later that day and told us all about League of Vendors. The second, the most recent time was on September 25th, when she randomly came by my house.
Most recently, what did you investigator talk about?
It was pretty weird. She kept asking about this old truck that I had.
Would you recognize the photo of that truck was shown to you?
Of course.
Your Honor, the defense is Martha is offering as defense Ms. Stewart, looking at this photo, how would you describe your truck?
It's ancient, raggedy, pretty unmistakable.
You may put that aside. Returning to your conversation with the investigator, what did she ask you about your truck?
She wanted to know where it was in the night of the theft,
Where was it?
where it always is in the middle of the night. In my apartment's parking lot.
Objection, lack of foundation, perhaps witness knows this information.
Your Honor, it's the witness's truck, as well as rational perception, where it was on one night, and the opposing counsel wishes to test the strength of this witness's foundation and to do so in proximate information.
Your Honor, if you heard,
Yes.
this witness may own the truck, but nowhere have they testified to know its exact whereabouts on that night. Cannot testify to where it was that night without laying more foundation on it.
I'm going to allow you liberal ground to cross-examination of this witness.
Sure.
Where was your truck that night?
Again, in my apartment's parking lot.
Did the investigator ask anything else?
Yes, after clear this, she was her driving permit ever brought my truck.
Had a comment?
Yes, but not that night.
And did the investigator ask for anything else?
Oh, yeah, as she was on her way out, she asked my license plate number, which I happily gave.
Finally, Ms. Stewart, I want to talk about your relationship to your cousin Carmen. Did Carmen ever loan you money?
Yes, back in 2023, Herman generously lent me $2,000.
Did he ever ask for that money back?
No, that's just the kind of guy he is.
Did he ever mention that back?
No, it was so long ago, we haven't talked about it since.
Thank you, Ms. Stewart. Thank you, Your Honor. No further questions.
Cross-examination.
Good morning.
Good morning. On direct, you mentioned this sum of the money that Erickson gave you, correct?
That's correct.
And you say that you owe Erickson $2,000, correct?
Yes.
And meaning that you owe it means that you have to pay Erickson back, correct?
Yes, although we have never been pressure.
That's it, you answered my question.
Yes.
And this is because Erickson paid for your bail bond, correct?
Objection relevant to the purpose of the matter.
This is because Erickson paid for your bail bond, correct?
That's correct.
After learning that your little cousin Erickson got arrested, you went on to call Chief Investigator Thomas, correct?
Of course, I wanted to know what was going on.
And one of the details you learned was that the crime occurred at around 2 a.m. on the 31st at the Burnett, correct?
Yes, while we were playing video games.
Your Honor, can I have everything except the answer to the next response?
Well, I'm going to allow the witness to answer. Obviously, you can ask other questions to make sure you get the answer to it.
I didn't ask you what you were doing. That is what you learned, correct?
Yes, that's what I learned.
And then you went on to tell Thomas that Erickson couldn't have been at the burn pit at that time, on that day, correct?
Yes, because we were playing video games.
But you cannot tell us where Erickson was then, correct?
I can,
And where was Erickson?
playing video games.
I'm not asking what they were doing, I'm asking where they were. You said that you could tell us where Erickson was, and where were Erickson?
In their apartment playing video games.
Your testimony is that Erickson was in their apartment, correct?
Yes, we were playing video games together.
You submitted an affidavit for this case, correct?
That's correct.
And you signed this affidavit under the list of perjury, correct?
Yes.
And you put everything you knew about this case in this affidavit, correct?
Yes.
And you had time to review this affidavit prior to this case, correct?
That's correct.
And nowhere in this affidavit do you say you know Erickson was in their apartment, correct?
I say that we were playing video games together.
But not in their apartment. You do not say that they were in their apartment once, correct?
Well, yes, we were playing video games together. We were playing monitors.
But you do not say it was in their apartment, correct?
That's correct, although rationally they were in their apartment.
I'm not asking you that, so nowhere in the affidavit do you say that you know they were in their apartment, correct?
That's correct.
So it's a testimony that you can tell us where Erickson was, but you cannot tell us where Erickson was, correct?
We were
Yes. There's a testimony that you can tell us that Erickson was at the burn, but you cannot tell us where they were, correct?
because they were playing video games.
But you cannot tell us where they were, correct?
That's correct.
And you guys were using League of Legends, correct?
Yes, they were.
It's an online video game, correct?
Yes, I was video games are.
You guys were using practice, correct?
Yes, we were into it, maybe a little bit of practice before playing.
I didn't ask why you guys were playing games. didn't ask why, but I only asked if it would pay for the credit. And that's correct.
Yes.
But I can sit back and the game will still continue on, correct?
Yes. Watching.
So I said yes to the question.
Yes.
And you own a truck, correct? And the license on the truck is LYC 3482, correct?
That's correct.
So your truck license has an 8, correct? And you said that you often park your truck in your parking lot at night, correct?
Yes, I always do.
And you and everything in the same apartment complex, correct?
Yes.
You didn't leave your keys in the truck, correct?
That's correct.
So this is the on the before that, correct?
Yes.
So your truck with the keys in it, it's not from core area to the apartment complex at night, correct?
That's correct.
And everything in your truck and everything needs, correct?
Yes.
Everything you have to ask permission before you use your truck, correct?
That's correct.
And it's your testimony that you know your truck was in an apartment complex in the whole night of August 30th to Northern August 31st, correct?
Yes.
But nowhere do you say you know how, correct?
I didn't hear any vehicles outside.
Nowhere do you say you testimony that you never heard any vehicles outside?
I didn't hear any vehicles. I don't recall hearing any vehicles that night.
And you have an affidavit for this case?
Yes.
And no one has affidavit to say that you never recall hearing any vehicles, correct?
I never said that I heard any vehicles.
So nowhere do you say that, correct?
I never say that I heard any vehicles.
And you never say that you didn't hear any vehicles, correct?
I never said that I did hear vehicles.
So you never said that you did or did not hear vehicles, correct?
That's correct.
And you never said that you looked at the route, correct?
No, we were looking at vehicles when I asked you to mention the my screen.
And you never said that you went on to check where your truck was, correct?
That's correct.
And you guys had it logged out of video, had it logged out of our club of video game until around 3 a.m., correct?
Yes.
And you testified that in our club, the game will pay for the player, correct?
Yes.
And the time occurred at 2 a.m., which is a whole hour before you guys had left our club, correct?
Well, we were in autopilot for a point of the night. It's unsure how long we were in it, but I just know we exited autopilot for a point.
Yeah, I had to show you that's not possible.
Well, my answer is I don't know.
Yes. The crime occurred at 2 a.m. on August 2025, which is a whole hour before you guys had left our club, correct?
That's considered.
No further question.
Minister, if you haven't heard your truck drive off in the middle of the night, would you include that in your affidavit?
Of course.
And Minister, have you ever taken your meetings outside of your apartment?
No, it's written in my monitor.
Thank you, Minister. Thank you, Your Honor. No further questions.
For your welcome to this. Now, you said that you know that your truck was in a complex, correct?
Yes.
But you didn't add an affidavit that you didn't do your truck. Sorry, correct?
I didn't mention it.
You didn't mention affidavit that you could hear your truck start from your apartment, correct?
We'll get someone in the second floor.
That's yes.
Yes.
No further question.
That's evidence, Casey.
Minutes number 7, all these are okay.
The box, raise your right hand. And you promise to tell the truth, whole truth, and nothing but the truth. Please have a seat. You may ask one.
Good morning. Please state your full name for the record. My name is Bill Garrett. What do you do for a living, Ms. Garrett? I'm now unemployed, but up until last year, I worked as a probation officer at Cook County Probation. How did you get involved in today's case? The defense asked me to testify, as I have permanent my work as a probation officer. We'll get to Carmen in a moment, but I'd like to talk more about your work as a probation officer. start working as a probation officer?
Right after graduating, so that would be in 2011, almost 50 years ago.
What was your role then?
I started as an entry-level probation officer.
Has your role changed over the years?
Yes, I was steadily promoted up, and by 2021, I've become a probation officer 4, which is the highest position a probation officer can hold before reaching supervisory status. But the core of my work, which is working with prisoners, never changed.
When did you stop working for Cook County Probation Department?
I stopped last year when I was wrongfully terminated. My appeal for wrongful termination is still pending, and I hope to return there as soon as possible.
As a probation officer, what do you do?
I'm there to support and evaluate my probationers.
How did you do that?
I would check in with them to ensure that they were complying with all the conditions of their probation, and I would also act as a guide for them on the path to turning lives around and becoming upstanding members of society.
Did you have any other responsibilities?
Yes, I also do pre-sentence investigations for the board.
What did that entail?
I would basically review the evidence and the facts of the case, and then I would submit my findings and my recommendations for a fair sentence to the court.
Now, I'd like to direct your attention to your relationship with investigative office. How do you know the investigator?
Though we had different jobs, we both worked in the Cook County justice system. So the investigations and the offenders we worked with would occasionally overlap.
What was your working relationship like?
It was tense. Unfortunately, we disagreed sometimes as we take different approaches to our work in the justice system.
Ms. Carrick, what makes you say that?
Well, Investigator Thomas was often criticizing me for not recommending harsher sentences in pre-sentence reports.
How do these differences affect your relationship?
Unfortunately, Investigator Thomas started filing false complaints.
What were these complaints about?
Objection, calls for speculation.
Your Honor, may I respond? Ms. Carrick worked at the probation department and was fired under a hearing panel due to the complaints that were made against her. Therefore, it is within her rational perception to testify as to what the complaints were about that led to her firing.
Your Honor, if I may, that may be so, but opposing counsel has not laid any foundation. If there was a hearing, this witness was at the hearing, whether this witness knows why they were terminated, so just ask them right away why they were terminated. Speculative, and ask opposing counsel lay a little more foundation as to how this witness actually knows that.
I'm allowed to.
What were these complaints about?
She complained that my relationships with the probationers were unprofessional simply because they were family. I was a probation officer for 14 years, and I know how to do my job well.
Well, let's talk about when did you become?
We met in 2019 when I became probation officer.
How did you work with Carmen as his probation officer?
The court required that we would meet every month for at least 30 minutes, so our sessions would go over time occasionally.
What were these sessions like?
I would check in with him, and I would give him all the advice I could about how to continue to stay on the right track. For example, by learning employee skills.
How did Carmen react to your advice?
He was really engaged.
Objection, speculation.
Your Honor, may I respond? It is within this witness's rational perception to say whether or not the defendant engaged in the conversations that she had with him.
Your Honor, this witness has no know the mental state, Carmen Erickson, whether or not they were actually engaged in these meetings.
Well, witness testified when she saw what she observed on the photo.
How did Carmen react to your advice?
As I said, he was engaged. By the end of integration, we were even discussing him going to trade school. Overall, I was really proud of all the improvement he made and all the work that he put into this probation.
Did you keep in contact with Carmen after this probationary period had ended?
Yes, I continued to check in with him every so often. I wanted to make sure he still had all the support that he needed.
How would you describe Carmen's progress at that point?
He continued to make really good progress even after the mandatory sessions were over.
Thank you, Ms. Garrett. Thank you, Your Honor. No further questions.
Yes, Your Honor. May I proceed? You were Carmen Erickson's probation officer, correct?
That's correct.
And during that time, you grew really fond of Carmen Erickson, didn't you?
Yes, he made a lot of progress on his path.
That's not what I asked. I just asked whether you were fond of them, and you did, didn't you?
Yes, I was.
And you even called Herman Harrison their nickname Ace, didn't you?
Yes, that's what he goes on.
But you did call them by their nickname Ace, correct?
Yes, that's correct.
But you are no longer Herman Harrison's probation officer, are you?
No, not since 2021.
And there is a rule in your government that prohibits personal relationships between probationers and ex-probationers, correct?
Yes. It's a very important rule that probation officers can build close and cooperative relationships with their probationers while maintaining professional honesty.
So you believe that this is an important rule, correct?
Absolutely.
And you are also fully aware of this rule, correct?
Yes. I always make sure that I abide by it as a very important rule.
Yet, you maintained a relationship with Herman Harrison that spanned several years after the professional probationary period, correct?
Yes, the mandatory sessions were over, but I wanted to make sure that he still had support and resources.
So is that a yes, you did maintain a relationship with them outside of professional boundaries?
I wouldn't say it was outside of professional boundaries. I was still doing my duty as his former probation officer.
It was outside of their professional probation period, wasn't it?
Yes, that's correct.
And you even considered your relationship with Herman Harrison a friendship, don't you?
Yes, you're right.
Now, you were eventually terminated from your position in the probation department in June of 2025, correct?
Yes, unfortunately.
And it is your belief the reason you were terminated was due to allegations of maintaining relationships with probationers and ex-probationers, correct?
Yes, it was all due to investigator Thomas's misguided complaints.
So you believe that investigator Thomas made these allegations against you?
Yes, that's what it said.
And you believe investigator Thomas's allegations against you are what persuaded the hearing panel to terminate you, correct?
Yes, I do believe that.
In regards to this, you stated that investigator Thomas's actions against you are unforgivable, correct?
Yes, his complaints were misguided.
So that's a yes, you did say his actions against you are unforgivable.
Yes.
Now, despite no longer being employed by the probation department, in September, you visited investigator Thomas at their office, correct?
Yes, at our office.
And this was to discuss your friend's case.
Yes, I wanted to give all the information that I had, as investigator Thomas's investigations are sometimes rushed and don't always find all the necessary facts.
Your Honor, I'd like to strike that last part, the latter part, as the investigation is being rushed is speculative and it being relied on this report.
Your Honor, Mayor Swan.
Yes.
Ms. Herrick worked with investigator Thomas for many years, and she testified on direct. They often overlap in work. Therefore, Ms. Herrick does not speculate when she states that investigator Thomas' investigations are sometimes rushed.
I'm going to split the difference. He listens to questions, try to answer the questions.
Yes.
Over.
I'll re-ask the question, okay? You visited investigator Thomas at their office in September, correct?
That's correct.
And the reason you were there was because you hoped to be gaining some information that would help in the defense of Herman Harrison, correct?
Did you think that?
The reason you were there was because you hoped to gain some information that would help in Herman Harrison's defense, correct?
I heard it gives information, not gain.
So is it your testimony today that you went there to give information and not gain?
Yes, absolutely.
You submitted an affidavit in today's case, correct?
Yes, I did.
And in this affidavit, you promised to tell the truth, correct? And you had a chance to review this affidavit, right in this case. And in paragraph 12 of your affidavit, you said, I should have just left, but I said to wait out on the off chance I might get some nuggets that could help Ace's defense. So I'll ask you again, were you there to receive information, or were you there to get information?
I was there for both. I was also there to give the information that I had about the
But in your affidavit, it says the reason you were there was because you were there to get information, correct?
That's correct.
Thank you. And some of the information you received there was that there was an eyewitness, there was a Herman Harrison at the scene of the crime, correct?
That's correct.
Now, Ms. Carey, since you're no longer Herman Harrison's probation officer, you're here testifying today as their friend, correct?
No.
You're here testifying today as their probation officer several years ago, correct?
Yes. I'm testifying as his former probation officer. Still knows him as a person.
Yet, you were not with Carmen Harrison, your friend, on the night of the crime, were you?
No, I was not.
But you believe in Carmen Harrison's innocence, don't you?
Yes, I do. I've been monitoring the charges for years, and I do not believe that he would be innocent.
That's not what I asked you. I only asked you whether you believe in your innocence, and you do, don't you?
Yes, absolutely.
In fact, you believe in Carmen Harrison's innocence unconditionally, don't you?
Yes, I do.
And unconditionally means, regardless of any facts presented to you, you would still believe in Carmen Harrison's innocence, correct?
Yes, no facts have been presented to me that would suggest that he's innocent, or that he's guilty.
So, is it your testimony today that no facts have been presented to you to suggest otherwise?
Yes.
You submitted that affidavit, correct?
Yes, I did.
And once again, in this affidavit, in paragraph 12, during your meeting with Investigator Thomas, one moment. You discussed how you learned of an eyewitness identification there,
Yes, I did.
correct? So you did learn of an eyewitness identification there, correct?
Yes.
Same.
It's flawed. I wouldn't say identification.
I didn't ask you whether the thing is flawed. I asked you whether you learned an eyewitness identification, and you did, didn't you?
Yes, to clarify, this is not suggesting that Carmen was guilty.
Okay, so as you were not with Carmen Harrison, your friend, on the night of the crime, you would have no way of knowing what they were or were not doing that night, would you?
That's correct. I wasn't.
Thank you, Your Honor. No further questions.
Whenever you're ready, Your Honor, I ask Ms. Carter to be excused.
And we may set that.
Thank you. The defense has 8 months.
I did.
Have a seat.
Good morning.
Good morning.
Could you introduce yourself to the court?
My name is Carmen Harrison.
Where are you from, Carmen?
I'm a New Yorker. I'm from Butler, New York, and I've lived here in my apartment for the last 3 years.
And why are you here today?
I'm here today to set the record straight. I was arrested without any explanation and then falsely accused of stealing cookie grease.
Let's start by talking about that arrest. When were you arrested?
I was arrested on September 9th at about 7:45 p.m.
And what were you doing before you were arrested?
I was leaving my go-to spot, Queen City Saloon, after shooting some pool with my buddy Carson.
Objection, Your Honor. Invention of fact. Amender. Nowhere in this witness appears sworn affirmations that she ever mentioned this as his go-to spot. If you'd like, Your Honor, I can handle my cross.
Panel.
Thank you, Your Honor.
Would that be Carson Walker?
Yes, that would.
So you were leaving the pool hall. What happened then?
We were walking outside, it was getting dark out, when suddenly, out of nowhere, some boys came up behind us and started shouting at us and calling us names.
Who was that person, Carmen?
At the time, I had no idea who the person was. Like I said before, it was getting dark. I just heard someone yelling.
And what was that person yelling?
That person yelled, "Hey, bozo, stop right there."
Did you ever come to find out who that was?
Well, it turns out that it was investigator Sal Thomas.
And that day, did the investigators say anything else to you?
No, that was all they said. They only called us the names and shouted us to stop. I had no idea what was going on.
Carmen, did you stop?
No, we ran away.
Why did you run?
It was dark out, like I said before, and Queen City Saloon is in a sketchy neighborhood.
Objection, Your Honor. A lack of foundation to how this witness would know that this is a sketchy neighborhood. Furthermore, it's also speculative as to why Carson Walker ran. This witness can testify to why they ran, not Carson Walker.
If I may respond, Your Honor? First, I did not ask my client whether or not Carson Walker ran or why he ran. I asked whether my client ran, as well as in his rational perception of why he was running. Second, Your Honor, my client has already testified that he spends time in this neighborhood. This is his neighborhood, and he's been to this pool hall before. It's all within his rapid perception as to whether or not he perceives it to be a sketchy neighborhood.
Your Honor, I'm respond. The information regarding this witness ever having visited this pool hall before is not contained in the affidavit, but for the sake of time, I will handle that on cross. Well, thank you. Overruled.
Carmen, why did you run?
I didn't know what was going on. Queen City Saloon is in a sketchy neighborhood. I didn't know what was going on, and I didn't want to stick around and find out. I was scared.
What happened after you ran?
The investigator caught up to me after a few feet, and only then did I find out that I was under arrest.
Did you know why you were being arrested, Carmen?
At the time, I had no idea. I didn't find out why I was being detained or what I was being arrested for until my arraignment the next day. I was stuck in custody all night.
And let's spend some time talking a little bit about what you were charged with. What were the charges?
I was charged with resisting arrest and petty larceny of the burn.
How much do you know about what happened at the burn on August 31st, other than what we've heard here in court today?
Not a ton. I know that apparently some people broke in and stole cooking grease.
Carmen, what were you doing on the night of August 31st?
I was at home in my apartment playing this video game, League of Avengers, with a couple of friends.
Which friends were you playing with?
I was playing with my cousin Billy Stewart and my friend Carson Walker.
How long were you playing that game for?
We were playing from 11 to about 4 in the morning, give or take, so about 5 hours.
Were all of you on the game around the same time?
For the most part, Billy was already online when I started, and Carson logged on a couple minutes after I did.
Let's now address a few of the prosecution's theories of the case. We've heard a lot of testimony today about a truck being used in the theft. Carmen, do you own a truck?
No, I don't.
We've also heard some eyewitness testimony here in court today. Did you know Terry Johnson before this case, Carmen?
Yes, we went to middle school together, though we didn't get along.
What do you mean by that?
I'm not proud of it, but I was a mess back in middle school too.
Have you changed since then?
Yes, over the past few years, I've worked really hard to do what I can to turn my life around and become a better person. I think I've made significant strides.
How have you done that?
Over the course of 2 years, meeting with my probation officer, who was a huge help, was great. We talked about staying out of trouble and making the right choices.
Carmen, to be clear, did you have anything to do with the theft at the burn pit on August 31st?
Absolutely not. I have worked really hard to get where I am, and I would never do anything to jeopardize that.
No further questions, Your Honor.
Your Honor?
Yes, we do.
Now, on direct examination, you stated that the pool hall is your go-to spot, correct?
Correct.
And you swore an affirmation, is correct?
That's correct.
And you reviewed this affirmation under the penalty of perjury, correct?
Yes, I was told to tell everything relevant to the case.
And nowhere in this affirmation do you ever mention this being your go-to restaurant, correct?
Yes, I really didn't think the court really cared so much what restaurants I frequent. I was just trying to add some on.
Furthermore, you mentioned that you visited this restaurant before, correct?
That's correct.
I apologize, restaurant, this pool hall before, correct?
That's correct.
And again, nowhere in this document do you ever mention having visited this pool hall before, correct?
Yes, once again, I didn't think it was relevant to the court how many times I had been out to this restaurant.
So just to be absolutely clear, you never mentioned anything of any of your prior testimony about having visited the pool hall before or otherwise being familiar with it, correct?
I don't believe so. I have to look back in my affidavit. I really don't.
And of course, in your testimony today, you've also testified that it is a not nice neighborhood, correct?
That is correct, unfortunately.
So just to clarify, you are able to claim that this is a not nice neighborhood despite never having previously admitted in your prior testimony to having been there, correct?
I know that people are often mowed in that area.
And so it's your testimony today. So to be clear, you are saying that you know the crime statistics of this area despite having never been there in your prior testimony, correct?
I don't know about statistics, I'm no crime reporter or anything like that. I know that there are often muggings in the area, just from what I've heard.
From what you've heard, correct?
From what I've heard, just, you know, this general knowledge.
And just to clarify, you've never stated that you learned this from what you heard in your prior testimony, correct?
I'm sorry, I'm confused.
You've never stated that you learned that this was a sketchy area from what you've heard in your prior testimony, correct?
I stated that it was a sketchy area because there are often muggings in the area.
But specifically, you just stated that you know that because of what you've heard. But you've never said the words what you've heard as the reason for this in your prior testimony, correct?
I don't recall exactly how I know this. I know for sure that there are often muggings in the area, just in my knowledge, which leads me to believe that it's not necessary.
Now, furthermore, you also were present for when Beauclerc was on the stand, correct?
I was.
And you heard when Beauclerc claimed that Ace is what you prefer to be known as, correct?
Ace is a nickname.
But specifically, the people who you call you Ace are only your close friends, correct?
Generally, we had a pretty close working relationship. She was very helpful.
So you say that Beauclerc is one of these close friends, correct?
Sure, a close professional friend.
Despite the fact that you heard earlier that Beauclerc is testifying as your former probation officer, not your friend, correct?
Yes, she is testifying from what I heard in her official status.
Now let's move on. Moving to your friend, Carson Blocker. He is your lifelong friend, I believe you call him, correct?
Yes.
And Carson previously worked at the Burn, right?
Yes.
But Carson doesn't work at the Burn anymore, does he?
No, he doesn't exactly.
Well, even before the coma, he was fired by Gail Burns from the Burn, correct?
Yes.
And you were upset over this fire, right?
Yes, I felt it was unfair.
And you even stated that Gail Burns would get her just desserts one of these days. It will happen, correct?
Yes.
And you yourself also don't have a full employment, correct?
No, I'm not full-time employed.
And you were unemployed since 2024, correct?
Yes, it's a tough job market out there.
And since then, your 26 months, 26 weeks of unemployment have run out, correct?
Yes.
So to clarify, those employment benefits have run out over a year and a half ago, correct?
Yes.
Now, because of this, you're always looking for an extra opportunity to make a buck or two, correct?
Yes, I'm looking for all sorts of work.
In fact, even making enough to just survive is tough sometimes, right?
Yes, it can be, but so far, I've made it work.
And you're facing charges of petty larceny in this case, correct?
Yes.
Now, specifically, you were arrested for this on September 9th at 7:45, correct?
Yes.
And the arresting officer was Sal Thomas, correct?
Yes.
And you do not contest that you ran from Sal Thomas, correct?
That's correct, though I had no idea at the time that they were investigating.
Your Honor, can I please strike the latter half of that response as non-responsive? I didn't ask him why he did this, only if he did this.
Absolutely.
Would you like me to answer the question? Now, you do not contest that you ran from investigator Sal Thomas, correct?
Yes, I ran away from the voice actor.
Now, Billy Stewart also lives in your apartment complex, correct?
Yes.
And Billy Stewart is another one of those good friends of yours, correct?
Yes.
And Billy Stewart owns a truck, correct?
Yes.
And Billy Stewart allows you to use that truck whenever you need it, correct?
Yes.
Moreover, you have loaned Billy Stewart some $2,000 in the past, correct?
Yes.
And Billy Stewart has never paid you back this money, has she?
Yes, I know she'll pay me when she has the money. I told her not to worry about it.
Your Honor, can I please strike that answer as speculative? This witness can't know what Billy Stewart will do in the future.
I'm going to allow it.
So, to be specific, Billy Stewart has not paid you back yet, correct?
No, not yet.
And moreover, your alibi. Apologize. And moreover, you genuinely believe that Billy Stewart and you are so close that Billy Stewart would do anything for you, correct?
Yes, anything within reason.
But you have said this, correct?
Yes,
Moreover, you've even stated that Billy Stewart will vouch for you, correct?
yes, she was there with me.
To be clear, there with you playing the video games, not in the same room, correct?
Yes, she can vouch for that.
Now, moreover, your alibi is that you were playing these video games from 10:45 to either 3:30 to 3:45 on the night of the crime, like morning of the crime, correct?
Yes, I was playing video games from time to time.
And moreover, this game has a practice mode, correct?
Yes,
And you were in this practice mode during that time, correct?
yes, we were new to the game, so it was a good way to learn the game without me.
I'm not asking you why you did this. You were in this mode, correct?
Yes,
And moreover, this game has an autopilot mode, correct?
yes, it does.
And you've used this mode quite a day, correct?
Yes, I've used this mode.
Specifically, you turned off this mode at 3 a.m. on the morning of the crime, correct?
Yes, I don't recall exactly when I turned it on, but I turned it on. I turned it off for sure at 3 a.m.
And you're aware that in autopilot mode, you can just sit back and watch the game itself, correct?
Yes, it's a great way to learn.
And more than that, the game will play for a player, correct?
Yes, you watch the computer do the
And to be completely specific here, the crime we're aware occurred at 2:15 a.m., correct?
That sounds right.
Thank you, Your Honor.
Reader?
No redirect, Your Honor. Mr. Erickson, be excused.
Yeah, give me a second.
At this point, Your Honor, we can
Thank you. I think it's by stipulation on both sides wanted to take a 5 and 10 minute break before we proceed on the oral statement.
Yes,
Yes, Your Honor, we had that be a 10-minute break due to the number of students trial, like a little bit more time to adapt.
I should say, take as much time as you need, but,
Let's try to keep it to 10 minutes.
Permission to receive? Thank you, Your Honor, and may it please the court. At the beginning of today's trial, this law told you that even the best plans fail. And while that's true, did he ever stop to consider that there might be no play, no jig, no heist, nothing of that sort at all? You don't dispute that someone's plan failed, but it wasn't Carmen's. It was the prosecution's, whose worky, unrefined, and slippery as oil case has only failed to meet their purpose. Their story stands in sharp contrast to this. We have presented the clear, broad story of Carmen Harrison, a loyal friend and generous cousin who was worked on to turn his life around. Carmen was reaping the rewards of his hard work on September 9, 2025, shooting gold with his friends. When he went to leave, however, his night took a turn for the worse. In the darkness, someone shouted, "Hey, bozo, stop right there." Scared for his safety and a crime-ridden neighborhood, Carmen began to run, as any normal person would. It wasn't until after a couple strides that Carmen realized the person he was running from was a police officer. He immediately complied. Despite this, Carmen was charged with resisting arrest. Section 205.30 of New York State criminal law says that a person is guilty of resisting arrest when he intentionally prevents or attempts to prevent a lawfully authorized arrest. While it is undisputed that Carmen prevented his arrest, the defense disputes that he did so intentionally. Intentionally is our legal system's most culpable mental state, more so than knowingly, recklessly, or negligently. To meet this burden, the prosecution had to show that Carmen acted with the conscious objective of preventing his arrest. That's reasonable doubt, a reason you must obey. But even if you believe that she told Carmen who was under arrest, that does not make Carmen guilty. The prosecution had to prove Carmen was aware he was being arrested. If Carmen didn't hear investigator Carmen's over the motion, thought she said something else, or simply didn't process what was said, that makes Carmen not guilty. After spending nearly a full day in custody, unsure why he was even there, Carmen finally learned what he was charged with. He used cooking oil from a big burns barbecue, a petty larceny. Section 155.25 of New York State criminal law says that a person is guilty of petty larceny if he steals property if he does so intentionally. While it is undisputed and an act of larceny occurred, Carmen didn't do it. The prosecution had to prove beyond a reasonable doubt that Carmen committed the crime. In other words, show that looking at all of the evidence, there was no reasonable explanation other than guilt. But the prosecution's investigation has wholly failed to meet that purpose. As you heard today, that investigation didn't produce any evidence. It didn't produce fingerprints. It didn't produce tire tracks. And it didn't produce equipment. It produced only the following. 1. A biased eyewitness who swore she'd do anything and everything to put Carmen in prison. 2. A single digit on the license plate of a truck that didn't belong to Carmen, didn't belong to Mr. Walker, but was in fact unlocked and easily accessed by any member of the Butler community. 3. A ribbon jacket that also didn't belong to Carmen. And 4. A video game that didn't follow Carmen's exact movements, but still places him at home by his computer at the time of the crime. Your Honor, that's simply not enough to convict or even to furnish this court with any sense of what happened that night. Now, the defense does not claim to know what happened in the early hours of August 31st or the birthday. We don't know who stole oil or why they did so. But what we do know is that Carmen didn't do it. As you heard from Carmen and Stewart, the two complicated video games together late into the night. August 31st was no different. That night, Carmen was at home with the game. He logged on around 10:45 before logging off closer to 3:45. His story was corroborated by his cousin, Miss Stewart, who he played games with, and by the investigator. The prosecution has claimed that Carmen took advantage of the game's autopilot and passive mode users to stay active while stealing oil. But this theory is absurd. As you heard from Carmen and Stewart, both video game fanatics, the two were new to the game who used these users to better understand how it was played. Had Carmen and a new player left his apartment to steal oil, he would have certainly lost to Miss Stewart, who neither side disputes was in her apartment while watching a game play. Instead, however, when Carmen exited autopilot, he began to win. He developed his skills by watching autopilot, not by leaving his apartment. But the prosecution has also implied that Miss Stewart is more than Carmen's cousin reading movie, but someone willing to lie on his behalf in exchange for forgiveness of the debt she owes him. But remember what Miss Stewart said in this court today. Carmen has never so much as mentioned that debt, let alone asked Miss Stewart to pay it back. Far away from Carmen in his gaming chair, because unlike what the prosecution says, Carmen didn't wheel his gaming chair and set up to the scene of the crime. The crime was taking place at Big Bird's Barbecue. The restaurant's owner, Miss Gail Owens, was the first to notice. After checking out the restaurant and heading home, she returned back to the restaurant's alarm system only to witness that fact taking place. Unfortunately for the prosecution, Miss Burns can't remember more than a single digit of the perpetrator's license plate nor a physical feature of either perpetrator. Miss Burns' inability to remember what happened is just one of the many reasons that the prosecution's story is as slippery as oil. Added to by the fact that here in court today, Miss Burns referred to Carmen as a source of distraction and engagement. She also said that of Carson's firing, it was as much about Carmen as it was about Carson. That is bias. However, despite this familiarity with both Carmen and Mr. Walker, when Miss Burns showed this incredibly powerful flashlight that we heard all about on the perpetrators, she didn't recognize Carmen because she didn't see Carmen. She also didn't recognize any characteristics of the truck she was looking at. And recall what Miss Stewart said about her truck. It's unmistakably unique. That The only thing Miss Burns remembers is that one of the perpetrators was wearing a jacket Miss Burns came to her rip. Your Honor, Miss Burns didn't see the jacket rip, she heard it. And then it crossed the moment, with two perpetrators fleeing and Miss Burns shouting, "Who knows what Miss Burns heard?" But even if you believe that Miss Burns heard a jacket rip, that does not make Carmen guilty. There may well have been 100 ripped jackets in the town of Butler, and investigator Thomas wouldn't know because, as she said here in court today, she'd investigate anyone besides Carmen. But even if you believe that Mr. Walker was wearing the exact same jacket as was at the scene of the crime, that still does not make Carmen guilty. It's entirely possible that Mr. Walker committed the crime with someone else. Mr. Walker committing the crime independently is just one of the many possibilities the prosecution failed to consider. You heard investigator Carmen testify that oil theft is widespread and rampant. But despite this, she didn't investigate anyone besides Carmen. The prosecution's only piece of evidence they claim ties Carmen to the oil theft is the eyewitness account of Miss Mary Johnson. Her testimony is as slippery as oil. As you heard from her today, she and Carmen had a bad relationship going back to middle school. In the time since then, Miss Johnson's feelings have really festered. She said here in court today she would do anything and everything to come from her prison, and that she thinks of Carmen the same way she did in middle school, as a bully and an awful person. When she saw that the restaurant behind her house had been robbed, she realized at the time had come to make Carmen severely. A promise she gave her sister. But her plan has clearly failed because the testimony she's provided in this room today is simply unbelievable. She told you that after witnessing a robbery, she waited 2 days to contact the police. She said she waited 2 weeks to convince herself she had seen Carmen. In other words, her mother was worth the risk of lying to the police to bring her enemy down. Evidently, she decided it was because, despite her initial hesitancy, she told the investigator the person she had seen was definitely Carmen. That's a shocking level of certainty, given that she couldn't identify a single physical feature of the other perpetrator. But investigator Thomas didn't find that suspicious. After hearing about all of this, she presented Miss Johnson with a photograph, effectively giving Miss Johnson the tool to do what she wanted and put Carmen in prison. Don't follow investigator Thomas's same path. Don't rush to accept the prosecution's oil slick story. We ask that you find Carmen Erickson not guilty. Thank you.
According to the nominated for subvention, to cover 2 pieces of evidence. Yes.
Your Honor, even the best laid plans often fail. May it please the court. The prosecution has shown today how Carmen Erickson committed the crime of petty larceny when she stole property in the form of used cooking from Fayetteville-Manlius on August 31st. Furthermore, they have also shown that she committed the crime of resisting arrest when she ran from and struggled with police officers effecting a lawfully good arrest warrant on September 9, 2025. And you might ask yourself, who in the world would steal used cooking oil? And moreover, blindly target male girls in the birthday? Well, to answer that question, let's take a step back and examine who exactly Carmen Erickson is. Carmen Erickson is unemployed and has been so for years. Take what she said, he said on the stand today, making enough to justify his awesome laugh. Moreover, Yale burning for the murder but also not letting target. As far as the blogger, Carmen Erickson's friend, is also employed, but only recently, after he was fined just 6 weeks before the death by Yale burns from the murder. What was his job in hands? Working with the used cooking oil. So, Carmen was upset with this, and was too young to make a plan. They knew where the oil was in They knew how much oil would be there. They knew how much the sale of that oil mattered to Dale Burns, and they knew when the oil bags would be most full. So Carmen parked the Hudson truck, drove to the market just after it closed, and in under an hour sold over 200 gallons of oil before leaving. They knew what they were looking for, and they knew how to find it. But even the best laid plans often fail. And this one wasn't a particularly good one, and it showed. The first hiccup came when Gail Burns, the owner of the restaurant, returned. She, upon finding them the vehicles doing the cook shining a bright light, and yelled for them to stop. We heard earlier how Carson Walker turned to run and got her jacket, his jacket ripped. On the nail of the tree, from the back door. Before the two of them got into the truck and drove away to a Gail Burns home for 8 and the license plate. Now, this jacket, which on the night of arrest, places Carson Walker at the scene of the crime. Well, the defense alleges that Carson Walker simply isn't relevant to this case. After all, he could have gone to someone other than Carmen Erickson. However, it is relevant to one thing. It is relevant to their alibi. Allow me to explain. As this picture shows, on August 21st, this jacket, worn by Carson Walker, despite the fact that it was worn all the time, it is ripped. It's pristine. But, Your Honor, by the time he was arrested on September 9th, he produced a prominent lip along with that here, aligning the timing of that rip with that of the recent crime. Now, it is true that Carson Walker was at the scene of the crime, but if Carson Walker wasn't playing video games, if Carson Walker wasn't playing video games, then part of the alibi is incorrect. If part of the alibi is incorrect, then the whole alibi is not to be trusted. And, Your Honor, if Billy Stewart was wrong when he gave an alibi saying, we can't trust anything he said. Now, the jacket is the only thing in Carson Walker. There is a crime. As is a second eyewitness, Mary Johnson. As you heard her say on the stand today, she went back to the walk around in the morning to see white light shining through the window. And naturally, she woke up when she saw someone she recognized, Carmen Erickson, getting into a pickup truck and driving away. Now, that's a little strange. That's to them, but it's not yet crime. However, later, when she learned that at that exact moment the restaurant nearby has been broken into and had its own oil stolen, now she knew what Carmen Erickson was doing outside the window at such a early hour. And as a huge responsible citizen would, she reported them to the police. Now, you might notice that the defense has spent so much time focusing on Mary Johnson's past history with the defendant, but whether or not Johnson likes Carmen Erickson doesn't change the fact that everything she said lined up with the testimony of Dale Burns. Are we just supposed to assume that Mary Johnson was happy to make up a testimony entirely consistent with the facts of the case and it was presented by Dale Burns? It makes a lot more sense that Mary Johnson saw Carmen Erickson doing something outside the window. And when she later learned that something was a crime, she was willing, as any responsible citizen would, to report them to the police. Furthermore, the defense is found out what exact moment she became 100% certain about the explain. As you heard from Mary Johnson herself, she was 100% certain it was Carmen Erickson, but she wasn't sure of who she saw. Later, when she was going forward, she went immediately to the person that she saw, Carmen Erickson. She was right. Your Honor, the defense is trying to split up witnesses, focus only on what each witness did see, but I would like to remind you to focus on how much each witness saw. Both witnesses saw the crime occur around Joanne. Both witnesses saw two individuals in a pickup truck to drive away. In fact, the only major difference between Dale Burns and Mary Johnson's testimony is that Dale Burns saw Carson Walker with a ripped jacket into the passenger side, while Mary Johnson saw Carmen Erickson get into the driver's side, taking together the evidence of Carson and Carmen at the scene of the crime. With this evidence from lots of evidence saw competition or in subsequently received in a restaurant. We heard earlier that she chose to at that restaurant outside of the public. The safety of all those involved. We heard that she announced herself saying, "Hey, Carmen Erickson, you're under arrest." And while the defense is trying to find out exactly what happened, you don't have to take my word for it. You don't have to investigate yourself, Thomas' word for it. Take what the defendant herself admitted. Himself admitted. He ran. Now, the defense is claiming that she didn't know. He didn't know that he was being wanted at the time. He believed it was being wanted. He didn't think that he was under arrest. The fact is that by the time that he was struggling to avoid being detained by police deputies, he knew that he was under arrest. And Carter Erickson tried to explain the reason why she ran away as simply because the area was sketchy. But he has never mentioned so much as being in the area before his testimony. And had to resort to invent facts about him learning about this on hearing someone. Facts that are never included anywhere else within this case, just to try and make you believe that somehow he didn't know that he was under arrest, despite the fact that he had been told that. But Carmen Erickson knew that arrest was a possibility. Carmen Erickson had a plan. That is, they had Billy Stewart. This is same Billy who is Carmen Erickson's good friend. He's Carmen Erickson's husband. Only to pick up with them a great relationship. And, Your Honor, owes the defendant $2,000, and some of the defendant believes would do anything, even without for that. Now, let's take a look at the overstated facilitated oil in today's case, the defendant's alibi. Now, it is, as you heard from the Stewart on the stand, that he simply heard it because, after all, it was playing video games from 10:45 to 3:30. In fact, however, their alibi is so problematic that the alibi with this Billy Stewart had to resort to inventing facts on the stand of where Carmen Erickson was. The simple fact is, she doesn't know. All she knows is that she was playing video games. They couldn't see each other. They were in the same apartment. That's enough. They could see each other in the video game. They were playing the video game. However, Your Honor, the simple fact is that it's not. And this video game, as he practiced it, he orders him to turn it on and walk away to leave the game was identical to if they had been playing the whole time. Now, I'm not a little confused when I mentioned game logs there, but I don't blame him. Because rather than defense provide this alibi, they have tried their hardest to prevent us from moving close. Yeah, take the game logs for instance. When we tried to provide them provides necessary context about that alibi, they rejected it. They do not want the game. They don't want looking closely at the evidence because they're afraid of what you might see. Your Honor, if that's not considered on the game at all times, any over simply turning on the game and walking away would let the game play itself. We would just sit back and watch the game play itself. To make this a little more clear, I'm asking you to look at this. At around 10:45, the defendant entered the room, which then he then turned on the light. That might be the video games. He then left that room and then coming back at around 3:30 to turn it back on. Now, the defense alleged that the fact that the light was on from 10:45 to 3:30 means the defendant must have been in the room for that time. But I ask you to remember the old adage: just because the lights are on doesn't mean anyone is home. And in this case, Carter was not. Now, the prosecution recognizes that when the burden of proof to prove beyond a reasonable doubt that Carter Erickson committed the crime of petty larceny on August 31st and resisted arrest on September 9th. All the facts, evidence, and testimony you will see today prove that it's exactly what Carter Erickson planned to and did. But even the best laid plans often fail. It failed to be spotted by Jerry Johnson and Dale Burns. It failed when investigators out on the top of the alibi. And Your Honor, it failed today. We simply have never proven our case, and therefore ask you to find the defendant guilty.
Again, I'm Oliver Young. I chair the non-trial subcommittee of the Law Use and Citizenship Committee. And on behalf of the police subcommittee, I want to congratulate all 18 that competed in this year's statewide finals. I refer to the teams as the Elite Eight, and you certainly are. You received accolades from the various speakers and presenters over the past couple of days, and those comments are true and warranted. And I echo those comments that you received from those various speakers. I especially want to thank the two teams that just competed for you this morning. They have shown their excellence in putting this case on. It exceeds our expectation when we were putting this case together 6 months or so ago. And both teams have acquitted themselves well in their presentation. So I think another round of applause is in order. Your judge this morning is the Honorable Craig D. Hanna. Now, Justice Hanna is an associate judge of the Appellate Division of Court Department, and they're based in Rochester. That court is one of the 4 intermediate appellate courts just below the New York State Court of Appeals, our highest court. Now, before ascending to the appellate division, he was a justice of the Supreme Court, 18th Judicial District, which is pretty much Western New York. Before that, he was the chief judge of the Buffalo City Court, and also served as the supervisory judge of the 11 city courts in the 8th Judicial District. Now, Judge Hanna began his judicial career in January of 2006 when he was appointed to the Buffalo City Court by the mayor of Buffalo and was elected to a 10-year term the following November 2006. Before his judicial career, he worked as an assistant district attorney in the Erie County District Attorney's Office, and later as an attorney in the City of Buffalo Law Department. Prior to his time with the Buffalo Law Department, he was a trial attorney, primarily in the areas of personal injury and criminal defense. The judge is a graduate of Canisius College, now University, and received his Juris Doctorate from SUNY at Buffalo Law School. Now, it would take me half an hour to read his full bio. And his full bio is on the website of the Court Department. And I encourage you to invite you to go and read his full bio, and it's quite impressive. I will show you of that, his background and his credentials. So I want all of us to thank Judge Hanna for participating in this endeavor this morning.
Thank you, everyone. Again, give yourselves a round of applause. I am my mother's overeducated son that couldn't keep a good job. I am on my, I would probably say, 11th job since I graduated from school. And I say that because we all have these grandiose plans. I just want you to plan on being surprised. You put the time, you put the effort, you put the sweat equity in like you did here. The world is your oyster, so I'm proud of you. I was joking with some of the staff when I was a junior or senior in high school, you guys are 50 times ahead. obviously, I expect the world out of everyone in this room. I did not do any volunteer work when I was in high school, and I want to be brutally honest. I'm pretty sure there's teachers rolling their eyes, or if they're not, they're not alive, they're rolling on their grave, that I'm actually a judge. But I say that, and one of my best things that ever happened to me is when a friend of mine who was not considering going on to higher education saw me leaving the law school, and he ran in there and signed up, and he said, if Craig Hanna can do it, I can do it. And I thought it was a slight, but then when you think about it, isn't it our job to make everything seem attainable for our friends and family? So we're supposed to live as we climb. And you can see something, and you can tell someone that it's not insurmountable. I can do it, you can do it, then you're really living your freedom. I am so proud of you. I can give you 100 comments, but I want to tell you one thing. If you thought I didn't listen to your objections, I was letting everything in. Because this is a trial, it's an exercise, and I didn't want people to have to rewrite their summation. I thought everyone did an awesome job. I thought your closings were amazing. I thought the way you were cross-examining the witnesses was awesome. I have a good poker face. So whenever, if you see me look away, that means you're doing a hell of a job. Because I don't want to make you think I'm totally engaged with you. So some of your witnesses, you might think, this guy couldn't stand me. I thought you were doing a great job, so there's no reason to look at you. So I think your witnesses are well prepared, your teams are well prepared. I know your counselors, your teachers, your instructors, they're immensely proud of you. Why don't we give them a round of applause? We're all winners, right? So I can throw this out. Before I announce the winner, I will say this, and I think everyone knows that this is a very close, tightly, evenly matched contest. If you like basketball, it was like the Spurs, and the Spurs look on that.
The Thunder.
Yeah, what's that team, the Thunder? It was like the Spurs versus the Thunder, equally matched. And I'm going to say everyone did an amazing job, but it is my job to say the winner on points